law and legal is always important. I mean, that doesn't change no matter what your industry, no matter what you're building. I mean, it's important even if you're not an entrepreneur. That being said, coming into Web3, especially when I was new, it kind of blew me away how many projects were flying under the radar. Well, not flying under the radar, but that knew what they were doing. But I guess some of them that didn't, but were just completely avoiding legal advice. It's unfortunate, right? You know, a lot of people with really good ideas, really good passion, great products, right? Great value propositions. And so, I mean, and Daniel, tell us, sometimes it can be easy, sometimes it's not as easy, but it's easy to just remember that always talk to a lawyer about a lot of these things, right? And make sure to get these things sorted out, make sure you're doing it the right way, a way that's, if you are fundraising, that is in line with that. Definitely spoken too much, but on that note, I was really honored that Danny willing to spend the time with us. He is, I'll let him speak to his experience, but my go-to blockchain, NFTs, Web3 legal expert. And yeah, really grateful to have him on the call here. So Danny, take us away. We're all yours.
All right. Thanks for the kind introduction, Benny. Really appreciate you organizing this. It's great to see it all come together. And thank you everybody for taking the time to listen to me speak today. I'm going to share my screen. Give me 1 second here. Can everybody see my screen?
Not yet.
Not yet. Okay. How about now?
Yes, we do.
Okay, great. So today we're going to talk about how to legally run a Web3 project. This presentation usually takes me about an hour and I run short, so I'm going to try and blitz through this as fast as possible so we can cover as much as possible. Standard legal disclaimer. This presentation is not meant to create an attorney-client relationship. I'm not your lawyer. This isn't legal or financial advice. Also, everything in the crypto world moves incredibly fast. So what I say today could be outdated tomorrow. So if you're watching a recording of this, please keep that in mind. A little bit about me. So my name is Daniel Weiss. I'm an attorney and a CPA. I'm a partner with Falcon Rappaport Berkman. We're based in New York, but I am based in Miami. I'm part of the emerging technology team. We have about 7 lawyers on the team where we focus pretty much exclusively on this stuff. I'd say 75% of my days are focused on NFTs, blockchain, Web3. I come from a general counsel background. I was general counsel for 6 Rent-A-Car for the US. So, you know, I think one unique perspective I bring is I analyze things from both a business and a legal perspective. At the general counsel level, you're essentially a business person. So I think that gives me a bit of a unique perspective. So today we'll talk about entity formation and founders agreements, intellectual property, terms of service, general contracts, employment, securities and other regulations, and DAOs and tokens. So when it comes to entity formation, you know, there's huge variety in what makes the most sense for your project. And it really takes a fact-specific analysis of what are your individual circumstances. What I could tell you is you definitely want some sort of an entity. We've seen a number of individuals who fail to form an LLC, who fail to form a C corporation, who fail to wrap their DAO in an entity. And it creates a lot of problems for them and a lot of liability and exposure down the line. So you always want to form some sort of entity. And it's very fact specific. You know, what state are you located in? What country are you located in? Where are you doing business? Are you looking to raise funds? If you're looking to raise money, you know, you're probably going to want to go with the Delaware C Corp. That's just the standard. If you're looking to form a DAO and you want to save on costs, maybe you form an UNA, which is an unincorporated nonprofit association, and you register that in Wyoming, which has favorable DAO legislation. It's really a lot of discrepancies, but the key is that you have to form something. We see a lot of really brilliant people who have these great products who will go online and copy some documents, maybe register an LLC somewhere, and that's all they do. And it doesn't provide any meaningful protection. So not only do you need an entity, but you also need to know which the correct one is and to file or to create the correct documents that go along with it. You know, one issue we see all the time, especially in Web3, is you have these co-founders who are really good friends and they form a business and they have handshake agreements. And this becomes really problematic down the line when they get into disputes, when equity is called into question, when they're giving out equity to other people. So as tempting as it is to have a handshake agreement with one of your friends, as tempting as it is to download a form offline, you really want to talk to somebody with experience when you're forming a business to make sure you have the adequate protection that you need. One thing that everybody talks about these days is going offshore, and going offshore can definitely have huge advantages, but it's not this regulatory free pass that a lot of people think it is. If you or your co-founders are US citizens, if you're doing business in the US and you're selling to US people and you're located in the US, just because you form an entity offshore doesn't mean that you're going to be protected from regulations. Could have favorable tax advantages. It could provide some regulatory protections for you, but it all depends on how you structure it. Right now, for the past 2 weeks, I've been looking heavily into what the best format is for a DAO. It's really important that you have separation between the two, that you have an entity where the NFT could be issued, you have an entity that wraps the DAO. And when I say wrap, it just means the DAO is housed in this entity. So that could be an LLC or a C Corp. It could be an offshore Cayman Islands corporation or LLC. Switzerland has great laws when it comes to this, but those are very expensive. So we're looking into alternatives that are more budget friendly. One project that we're looking into is the Marshall Islands DAO. They have really friendly DAO legislation in there. It's much more reasonable from a cost perspective. And they have great favorable tax laws. So, if you're looking to form a DAO, there's this concept floating around out there that DAOs are replacing corporations and they're replacing LLCs, and it's a new way to do business in Web3, and it is. But with the current legal and regulatory regime, just because you want something to be a certain way doesn't mean it actually is that way. So if you do not have an entity to wrap your DAO, as a founder of that DAO, even if you divest all of your interest later on, you could be exposed to liability down the line. And worse than that, if you don't have an entity to wrap your DAO, you can expose your members to liability because they could be considered individual partners. So this could have huge tax and legal ramifications for them. So it's really important when you're doing this stuff to talk to experts and to figure out your actual goals and even determine, hey, do I really want a DAO, or am I just doing this because it sounds good? Intellectual property is obviously a big deal in this space. You want to have some sort of an IP strategy. You want to make sure that you're getting trademarks for your name and your brand. You want to make sure that before you spend a bunch of time and money promoting your name and brand, that somebody else doesn't have a trademark for it. One of the common things we see, the missteps we see, is that businesses do not secure intellectual property from their independent contractors. And so to explain what this means, if you are a business and you have an employee and they develop some code for you, they create some IP, as their employer, you automatically own that intellectual property, okay, because of the employee-employer relationship. This is not the case with independent contractors. If you hire an independent contractor, a third-party dev shop, to develop some intellectual property for you, even though you're paying for it, even though they're developing it for you, they still have ownership over it. You just have the right to use it, but it's not an exclusive right. And the way around this is you have very specific agreements in place with these dev shops or these other independent contractors where you specify that whatever intellectual property they're creating for you is work made for hire, and that they're assigning all of their rights and interest in this intellectual property to you. So this is a very common misstep that a lot of people make, so I want to highlight that here. I could go on and on about copyright and trademarks and everything, but for the sake of time, we're just going to keep moving. Terms of service and privacy policy, not sexy stuff, very important. So if you are in Web3, you're doing business online, and the terms of service is oftentimes your only opportunity to get a contract in place with the people that are using your services. So it's really important to have this in place. It provides a lot of protections for you. Often what you'll see is that some business, you scroll down to the footer of their website, they'll have a link for terms of service, they'll have a link for privacy policy. Sometimes they copy it from other people. And you really don't want to do that, because you want to be specific in terms of what service you're offering, what the terms related to that are. Are you allowing refunds? Are you not allowing refunds? What intellectual property rights are being granted? You want to have you want to have disclaimers in there, not just for standard things as far as, hacks, whatnot, but also for securities law compliance, especially in Web3. You want to have limitations of liability. You want to have indemnification terms in there. And one of the key things in terms of services is arbitration provisions, which, without getting too deep in the details, help prevent class action lawsuits from being filed against you. So those are really important. Privacy policies. If you're doing business online, you are collecting personal data. Personal data can be as simple as a name or an email address. So theoretically, you might not be, but pretty much everybody is collecting some personal information about somebody. And when you're collecting personal information online, you have to have a privacy policy in place that states how you're protecting this information and what individuals' rights are related to this information. And unfortunately, if you're doing business in the US, you're subject to the most restrictive state, which is California. And they have continuously rolled out stricter and stricter privacy requirements. Other states are following suit. Then you have GDPR in Europe. You have a variety of other privacy policy requirements throughout the world. So really important that you address this, talk about what information is being collected, how it's being collected, what information is being collected automatically, how the information is being used, and how users can see and change the information that's being held by them. So as I mentioned before, a lot of times you'll see a website, and at the footer of the website, you'll see a link to the terms of service. By the way, terms of service, terms of use, terms and conditions, all these terms can be used interchangeably. But the problem is if you just have this on the bottom of your website, a court could, and they have determined that individuals who visit your website haven't consented to these agreements. So they're not binding. So they don't accomplish the goal that they're trying to set out. So what's really important is that it's at some point in your user flow that you have individuals click a box saying that they consent to the terms and conditions. I have an example right here. I mean, this is simple stuff, but it makes a world of difference. This could mean the difference between you being exposed to a class action lawsuit or you not being exposed to a class action lawsuit, which could mean the difference between your business surviving or your business going bankrupt. So really important to have some sort of check the box in your user flow. And this could be challenging. You don't want to create an experience that sucks for people to use. So if you're selling something on your website, it's usually at the point where they're electing to purchase, where you make sure they click something like this. If you have an NFT project, it could be difficult. Let's say you do the original mint on your site, but then later people are buying on secondary markets like OpenSea. This is going to happen. How do you get them to consent? It's still ambiguous at this time. We don't really know. So we recommend to our clients that in the smart contract themselves, they make reference to the terms and conditions and the privacy policy. So there's different creative ways you could address this. And again, like everything else, it's specific to the facts and circumstances of your individual business. As you go on, you're going to be dealing with a number of different contracts and partnerships. One misstep we see often is with advisory agreements. Advisors and consultants, they offer huge value to projects who need their guidance, but a lot of times these agreements, they don't have any teeth to them. So you could be granting a significant amount of equity to an advisor, and then this advisor doesn't uphold their end of the bargain or what you thought was their end of the bargain, because you don't have anything meaningful in the agreement that requires them to do this. So you don't want to go overkill with advisor agreements to scare them away, but you also need to have some teeth to the agreement to make sure that they're doing what they need to do. And this is important with a lot of agreements that you'll see. People will send you a one-pager and you think, oh, great, I don't have to review this long, complicated contract, but you might not be getting the protections that you actually need. So, be wary of really simple, really light contracts. Two other points on contracts, particularly with advisory agreements. A lot of times you're granting equity, and you need to contemplate a grant of equity in your foundational documents, your operating agreement where equity is set forth, or you're going to need to go in and amend those documents later on. You also need to determine, where is that equity coming from? Do you have 3 co-founders with an equal split? Are you splitting the equity for this new advisor pro rata? Does it depend advisor to advisor? So these are all things you need to think about. And there's very specific documents you need to put into place in order to memorialize equity grants that are actually occurring. The other thing I'll say with contracts, where we see, people will sign a one-page agreement, but the one-page agreement will grant huge intellectual property rights to the other party, where, especially in the case of an NFT, you could be giving them the right to make derivatives of your product and do whatever they want with it, which really dilutes your brand and the value of your intellectual property. So always be careful with that. Benny, how am I doing on time right now?
A little bit more time, probably 5 minutes is the cap.
Okay. So this isn't sexy stuff, but independent contractors versus employees. If you have somebody that's working for you 40 hours a week and you're telling them exactly what to do, that person's probably an employee and not an independent contractor. Now that, especially in Web3, we have these distributed workforces and everybody is remote, it's easier to say, oh, this person's an independent contractor and I'm going to pay them X amount. I'm not going to have to worry about withholding. I'm not going to have to worry about insurance. But it exposes you in 2 ways. If the IRS comes and audits you, it could expose you to significant back taxes and penalties. And if the worker files a claim against you, which we see literally all the time, they have huge leverage against you because they were misclassified. Another note on independent contractors versus employees, especially as it pertains to this, is payments in cryptocurrency. So this varies state to state. But if you have a distributed workforce, a number of states don't recognize cryptocurrency as legal tender under their minimum wage requirements laws. So in every state, there's a requirement to pay individuals a minimum wage. So you could have some high-level person who you're paying, the equivalent of like $200,000 a year in ETH. But because ETH is not considered legal tender under certain state laws, you're in violation of minimum wage requirements. So this is something to bear in mind as you're paying your workforce. One workaround that we've used in the past is partial payment in fiat. So that you're making sure you meet the minimum wage amounts, and then you can pay the remainder in crypto. Also, this does not apply to independent contractors. As of now, you could pay your independent contractors in cryptocurrency because independent contractors aren't subject to these minimum wage requirements. But again, if you're misclassifying one of your independent contractors who really should be an employee, and then you're paying them in cryptocurrency, you could be facing a double whammy there. So things to keep in mind.
I have had several conversations with you. I've studied this. It's something that I learned a number of things there. The 1099, yeah, like both the minimum wage requirement if you're paying in crypto, and that was brand new for me. So thank you for that. Thank you so much. Do please drop your contact information in the chat so people can get in touch with you, because unfortunately we don't have time for Q&A right now, but we will save these questions. I'll forward the chat to Danny. So people that have questions, feel free to ask him, and Danny drop that in. So before we go into breakouts, we're gonna, and thank you so much. Thank you once again. In fact, let's give a round of applause. Let's start doing that. Round of applause, everybody.